Various types of online dispute resolution exist, and many of them reflect offline processes. You can have offline arbitration and can have online arbitration, online mediation, offline mediation, but the way it is conducted is of course different when you do it online, different from when you are doing it online. And on top of that, online dispute resolution also offers additional ways of resolving disputes. Namely, when only technology is used, then you have a type of dispute resolution that can't be reflected offline, because offline you always need people to mediate a process, or people that help to negotiate towards a solution, or people that help to decide a case. And all those features can be taken over by technology in a more or less sophisticated way, depending on what process you use your technology in. The basic forms of online dispute resolution are similar, as said, to what's existing offline. And at the top of the spectrum you have litigation, online litigation. You could argue whether it's part of the field of online dispute resolution, because when it started, online dispute resolution, a little over 10 years ago, there simply wasn't any online litigation. And as you know, the judiciary is quite traditional, and still today there isn't that much online litigation present, but you see more and more, both in the acts that are enacted. So you have codes, for instance in the Netherlands, on parts of the litigation process becoming possible online. So both in terms of codes and in terms of practice, filing documents for instance, you see more and more online elements being introduced in litigation. But as said, when online dispute resolution started, there wasn't any online litigation. So online dispute resolution, although the term alternative is not part of it, was seen as the online variant of alternative dispute resolution. So you could argue whether online litigation is part of online dispute resolution or not. If you look in the Directive 2031 on electronic commerce, you will see that there's a distinction made between alternative forms of dispute resolution and litigation, but for both processes it is stressed that electronic equipment should be used in those processes. The top is litigation. If the top is litigation, then the bottom, or the most lowest part of online dispute resolution, is online complaints. And again, you can argue whether online complaints is part of online dispute resolution, because if someone files a complaint that a company isn't satisfied with how the company treated him, for instance, you can argue whether there is already a conflict or not. But still there's a lot of similar technology used in online complaints processes as is used in online negotiation, online mediation. So I normally also had online complaint under online dispute resolution. And for electronic commerce, online complaint is a very important part of online dispute resolution. Were it not online dispute resolution per se, then it is indeed online dispute resolution in terms of conflict prevention, which should definitely be part of online dispute resolution. Then at the core of online dispute resolution we have arbitration, mediation and negotiation. No one will argue whether or not this is part of online dispute resolution. And those processes are not the same, of course. In arbitration you have most formality, and the process is quite document based. The exchange of documents is very important. You also can have hearings in arbitration, but then the use of web conferencing tools can be very helpful, and it doesn't make much sense if you exchange documents electronically why you wouldn't have the meeting online too, in particular if parties are wide apart. Distance is an important reason, parties being at a distance, why online dispute resolution can be very helpful. If you're in different continents, different countries, or far apart in the same country, then it makes a lot of sense to have a process online, even if you are sort of mimicking a physical meeting by way of web conference. Online mediation. In online mediation, the parties' communication is facilitated by the technology. So the emphasis is on the oral exchange of information between parties. Documents can be used, of course, but it doesn't play such a central role as it does in online arbitration. And the parties are supported or facilitated by a mediator that mediates the process and tries to realize that parties reach a mutually acceptable solution. And also the mediator sometimes helps in drafting the contract that is used as the basis for the outcome of the dispute. So whereas in arbitration the outcome is a verdict or an arbitral award, in case of mediation the outcome of a dispute is a contract in which the issues that were under dispute are resolved. All are resolved, or sometimes part of them are resolved in this contract, and the normal contractual rules apply to this contract. But it is of course a special type of contract because it is used to end a conflict. A contract is used to end a conflict between two parties. The last form then is negotiation. In case of negotiation, parties are fully on their own. They are only supported by technology, so there's no third human party involved. But you could argue that the third is still present in case of online negotiation, because the third is replaced by technology. Indifferent of whether you would see technology as a third party or not, the role of technology is of course most important in case of online negotiation, because there's no human third that can help to get the negotiation in the right direction. It's all left to the parties and to the technology. And I will show later on in this class some examples of the software that can be used to have a conflict resolved by two parties negotiating, only supported by technology.